Oh yeah, Middle East. Yeah. I like that. So.
Are we streaming?
Hey, how are you?
All right, good evening. Welcome everyone to the Cleveland Community Police Commission Rules Committee meeting. It's Thursday, May 4th. And we are here at our Perkins Avenue location with audience members and those online. It's 6:04 p.m. I'm going to call the meeting to order. Do a roll call. Commissioner Benito. Present. Commissioner Donaldson.
Present.
Commissioner Van Leer is going to be a little bit late. Commissioner Zayed.
Present.
And we have co-chair Jan Ridgeway.
Here.
Here. And we are not expecting co-chair Rodriguez.
Yes, she's just running late. She
Okay,
probably
she's-
is pulling out right now.
Okay, great. So, and I am present, I'm the chair, Teri Wang. So we will have a quick public comment period if necessary. We can hold comments for our two speakers. We're having Mr. Gordon Friedman and Mr. Teri Gilbert from the law firm of Gilbert and Friedman. They are longtime civil rights attorneys. And Mr. Friedman was also a former CPC commissioner. So if we have public comment, I can give a few minutes for that. Is there any interest? No? Does not appear to be, so we will move on. Oh, yes.
Yes, before we begin, I would just like to make a motion that we limit our guest speakers to no more than 15 minutes. That will also include question and answer, so that we can move forward in accomplishing and completing a couple of pieces of business that we really need to get in place prior to next Wednesday's meeting.
Okay, so there is a motion to limit the presentation of Mr. Friedman and Gilbert, who were told previously that they had 1 hour to 15 minutes.
I wait for the debate.
So is there a second for that motion?
Second.
Okay, and I will open up for discussion.
I guess I wasn't sure. I didn't think that either of these attorneys had been approved as part of our training process. Had they gone through the training committee, or this was only necessary for this rules committee?
They have not gone through any training process. They're here because of their experience in civil rights law and to give us a perspective, a necessary one from the defense about the Brady, Giglio, and Garrity doctrines and whatever. Just I think also a circumspect history of their work with the police and in Cleveland. So I think it's very topical. And we had initially wanted them to come in during a previous meeting, but we wanted to give space to those previous speakers who each did have 1 hour. So, and Mr. Friedman and Gilbert have made the effort today to come in. So I wish to give them that full hour. That hour will include public comments. I'm not sure how long they had planned. It's pretty free form right now. And we have another hour for old business or new and old business. So I guess I'm not under. Okay, so I think that it's even just out of courtesy providing our guests the time that was scheduled on the agenda, which was sent out already.
So is that an hour for each or an hour combined?
Okay. So it is. So are we going to vote on this motion, or is there any more discussion? But do you want? Is there any more discussion? Commissioner Zayed.
Oh, okay. To the chair, yeah, I think I understand both perspectives of, that that I think I understand not wanting to limit the time that, we told the guests that they would have. I think I also feel some concern about trying to get to some of the new business, and I understand that right now we have 50 minutes slotted for new business and old business, but given that some of those topics I think tend to require some discussion and perhaps debate even, and so and I am feeling a little concerned about the amount of time we've spent on Brady, Giglio, and Garrity. I think that at this point we have heard from quite a few folks, and I recognize that they have a different perspective to offer. But I think I also feel a little concerned about needing to get to some of the other business that we need to attend to.
Commissioner Syed?
I think that this is a little sudden, and I think that we should honor this agenda that we have before us, and we should also show some type of gratitude to our guests that came here today to help us free of charge, and I respect their time and give them the time that we promised them that we would give them.
Yeah, I wasn't saying not to allow them to speak, but I know that we have a couple of things that we really need to cover and get done for next Wednesday's meeting. So that's why I thought that we could.
I'm sorry, she was,
I'm sorry.
she was not finished.
When was this agenda sent out?
It was until, I had to finish it yesterday, but there was no discussion as to, it was sent out yesterday.
I just feel like if there was any issues, it should have been brought to the chair prior to this meeting right now.
The agenda was done at 8 a.m., so you didn't, have a lot of time.
Well, we had quite a busy week, and I apologize, and I had quite a busy week last week with a now deceased pet. But again, I don't, can I ask you just very openly, was there a discussion among you prior to this meeting about this issue?
So
That was not given to me?
So I would like to respect everybody's time. I think as a commission, we need to work on communication. And at this time, I would like to possibly call for the vote, even though I just walked in, because we are delaying time with this. So we're either gonna put a time and vote that up or down and move business forward.
All right, are we done with discussion? Okay, let's call the vote. Commissioner Benito. Oh, so repeat, the motion is to limit, what was it, now, did you want to make an amendment to your motion, or your motion
No,
stands?
it can stand as it is.
So the motion is for 15 minutes, right?
For each speaker, yes.
For each speaker. So, and then the additional
Question and answer period.
question and answer period. So that would equal almost about an hour.
Yes. No,
Yeah.
It's 30 minutes.
30 minutes.
30 minutes, and that includes the question and answer period.
Yes.
Okay. So that is 30 minutes, cutting down from 1 hour. Commissioner Benito,
Nay.
Commissioner Donaldson,
Abstain.
abstain. Commissioner Van Leer is not here. Commissioner Zayed,
Nay.
Commissioner Rodriguez.
So I would like to do a point of order because it sounds like it's more than 5 votes. And on a committee, you can only have 3 to 5.
And the reason why I have to interject why we have this is that we need to move to new business, and if you want to abstain, you can. However, last meeting, we told you the same thing, that there would be a quorum of 7, and you, I believe, chose to vote. So if you want to abstain, this is not something that would affect the entire commission, so I'm not sure if it would
Well,
even
an
matter.
abstention drops it anyway.
Okay,
So we're
so-
not in danger of
It's not.
So we're not in danger
it's
right
not a
now.
motion to change
anything in the rules.
commission, So we're fine.
Just as meetings.
So you can, and Mr. Van Leer is not here, so we don't have a majority quorum.
Okay. I'm gonna vote yay.
And Commissioner Ridgeway,
Yes.
and I vote nay, so the nays have it.
I think my request would be that after the presentations, we do try to maybe limit the number of questions from the community members, not because I want to stifle questions or their voices, but I think that is a way to both respect the presenters who are here, still allow time for maybe 2 or 3 questions, but also to ensure that we can get to new business.
Okay, so thank you so much for that comment. It is now 6:14. We're just 4 minutes behind schedule, but we welcome our guests, Mr. Gordon Friedman and Mr. Teri Gilbert. Thank you so much for coming. If you would come up, we have microphones for you.
Where do you want to sit?
Just, so the camera rolls in the front, Mr. Friedman, so if you step up here like in front of the screen, you're fine with that. But you do have to use the microphone, gentlemen.
Sure, we'll be together here. Here, let me go first.
Do you want to share or you have no PowerPoint for us, right? It will be just an open discussion and dialogue.
And you can use that mic, or you guys can share this mic here, whichever easiest.
We all set?
We're all set.
I haven't experienced the gag rule in my 50 years as a lawyer, so it's kind of an interesting proposition to go forward.
Right. Well, we understand that people have different feelings about why we're here. I don't want to regurgitate the education that you got with Jonathan Whitmer Rich, and I watched it, by the way, which was good background information about Giglio and Brady. You all know that. I and myself and Gordon obviously have close to 100 years of practicing law together, okay? Mostly criminal defense and civil rights. And yes, we have fought the city of Cleveland in litigation over the years. Just a little point of information, in 1984, I worked with the community to get the charter amendment changed to bring the police review board in, and went door to door getting signatures. In addition to my role as a lawyer in dealing with high profile and regular cases of police misconduct, not only in my civil and our civil docket, but as criminal defense lawyers every day in the Justice Center, dealing with police, witnesses, and so forth. So we have a lot to offer, and we're available. We're doing this voluntarily, and we hope that we can, provide some assets to you. Now, I looked at the charter, okay, and the charter is pretty broad about what to do and how to get this Brady material and Giglio. How do we find out who the bad cops are, who have, who should have been red flagged all along for prior misconduct of arraignment? And in the proposed manual, you list a whole lot of different kinds of misconduct, not just whether they lied on the witness stand or held back evidence, which leads me to believe that there has to be a robust process to get the information. Now, what I understand, there's a list, and the list is really a small part of getting the information about police issues and disciplinary issues in the past, or information from other sources about police who committed some legal infraction. Because what I'm thinking about is that the commission is only as good as the information it gets. And I mean, in a perfect world, I would say that there should be a very, broad database that can be, put together so that we know, when you're looking at a case, whether it's a review of misconduct or actually engaged in the process of having a hearing or whatever to recommend discipline, because now you have the power to actually impose it as a result of this new charter amendment. So how do you get this stuff? I mean, to me, the letter from the prosecutor's office is just a minuscule part of the whole picture, right? And so how do we get other information? Well, part of it is through the civil cases, which is what our expertise. In every case that we file, doesn't matter whether it's Cleveland or Akron or anywhere else, we do discovery. And one of the first things we do is subpoena all the disciplinary actions against a particular officer involved in the case, along with citizens' complaints. Now, we know historically that the Cleveland Police Department, and the reason for the consent decree was because it was a sham. The whole disciplinary process was unsubstantiated over and over and over again. And the plain dealer did a whole story about the fact that out of 11,000 complaints, like a handful of cases might have been sustained. So yes, we have a consent decree. Yes, there's been some progress, but I think per your mandate, there's more that can be done. So there are really only a handful of people like us around that do civil rights police misconduct litigation. Because it's difficult and it's very complicated. He's retired, but I'm still doing it, not for long. But so the civil rights lawyers have access to a lot of materials, but it seems to me that the city should not have to make you go through public records requests. There should be an agreement with the city that you get all the records of active police officers, okay, that are on the force, and put it together and have a way technologically to draw up information from that database when you're considering, was this person accused of excessive force? Was the officer holding back information? Was the officer lying on a report? And you would be surprised how many of them have been accused of misconduct. Not all of them, but enough. In my experience, many of the cases that I've had where there is a serious violation of civil rights, you get their records and you find a pattern, okay? That pattern is critical to your work. And so that's another way. So I'm thinking that, it could take a year. I was just meeting with the Marshall Project the other day because they want to do a data situation with the docket in Cuyahoga County with, the criminal cases to see what disparities are, racial, economically, whatever, and sentencing disparities and things like that. It took them 6 months to a year to do this study with, scores of people going over every case and putting it in a system. So that's one thing. The other thing is, in terms of Brady specifically, there's been a lot of exonerations of people who were innocent through innocence projects and things like that. Well, guess what? The Brady violations come from the police department or the prosecutor's office. So there are appellate decisions that have found that somebody who's been in jail 25, 30 years, whatever, can be released and get a new trial. And then the records of those cases might reveal misconduct by particular officers. And also talk to other lawyers that, criminal defense organizations that know about, certain officers. There's the twins, for example. What's their name? The twin.
Frickin' Fred.
Yeah, they were notorious for aggressive policing. You know who I'm talking about, Brenda.
Oh, yeah, Shoulders.
Terrence and I will. So the criminal defense lawyers know these things. So all I'm saying is to recommend there are resources for all of you to reach out to gather more information that will help your job. Thank you.
My comments are less prepared, and my response to Commissioner Ridgeway is that, with all due respect, I've trained the trainers. So to ask if we've been trained, whether it be Jonathan and Whitmer Rich or the whole crew, including Kerry Howard, I've trained those people. So I think training for me, something I understand, with all due respect. And I can only share with you by example why what you're going to do is so important. And that is that you have a lot of power to review police misconduct and police suppression of exculpatory evidence. Recently, I was engaged as a witness of a client that I represented 35 years ago in a capital murder case. And as a result of a very dogged lawyer by the name of David Singleton from Cincinnati, Ohio, Mr. Dwayne Brooks was given a new trial. Why was he given a new trial? Because the city of Cleveland and the police department suppressed exculpatory evidence that more than likely would have exonerated him, and he was granted a new trial. So the role that you have in the power that you have, which we never had when I was on the commission, we never had close to we were all volunteers. None of us got paid for jack. So I mean, you guys really have a lot of authority. You have the authority through the charter amendment, and you have authority through the consent decree. And I hope you all have read the consent decree, because it's essential. It's not a radical document. It's rather modest, quite frankly. But the city of Cleveland has failed, according to the monitoring team, by 38% to fulfill the consent decree. And as I said, not a radical document. Teri and I both worked on a case involving a man who spent 20 years on death row by the name of Joe D'Ambrosia. And he was released through habeas corpus because the prosecutor's office suppressed exculpatory information, exculpatory evidence. So with all due respect to Ms. Ridgeway, I'm not here to speak for an hour or even a half hour. I'm quick, I'm brief, and God bless. But I'm here to answer questions about Giglio and Brady. You also may want to take a look at a case called Jones v. Jago, which took place here in Cleveland, Ohio, where Harlow Jones was convicted of a murder that he did not commit. And Judge Frank Battisti, a former federal district court judge, granted him a new trial because the city had suppressed exculpatory information, which would have exonerated him. And there you go. My friend Jason told me that all these vignettes are old. What's new? Well, what's old is what's new. And I say to you that if you don't embrace your responsibility in this area, then you should not be on the police commission. If you're not ready to challenge the city, who you should cooperate with, but who, if you're not ready to challenge city and the police department, then you're not ready for this job. And also, I might say that you have a responsibility in the area of practice by virtue of training of the police department. I don't believe that the city of Cleveland police force knows what exculpatory evidence is, okay? I think that they should be trained in terms of when they come upon information, such as a witness that will say, that's not the person that did it, that they don't bury that interview, but that they have a responsibility to take that interview and present it to the charging parties. And the police department, professional responsibility, do not understand their obligation. And your responsibility is to get them there. That's all I have to say. And be happy to answer questions.
Thank you so much. So now we're open the floor to questions and discussion. Commissioner Benito.
Thank you both so much for being here. It is a delight to learn from you. I feel like I could probably listen to you tell stories for hours and hours. So
You can do that if you like.
Maybe
charge
I'll-
you.
Yeah, maybe.
He charges, I'm free.
I'll
So
take you out for pizza.
I live on Social Security, he lives,
I might take you up on that and take you out for pizza. Okay.
all right, we're kidding.
So one question, so, I don't know how much you know about kind of the part of, 115 that we are looking at creating in the Rules Committee right now, but basically, creating a public database of, officers that, are subject to Brady Giglio violations. Because right now, as you all know, it's very hush-hush, and it's even hard to nail down where these lists live and what information the prosecutor's offices and the police department has. Mostly so far we've been talking about, keeping track of the divisional notices that go out, asking to be CC'd and sent when letters are sent to the prosecutor's office or from the prosecutor's office to the division. But, I think some of the things that you've talked about is that, you guys come across and defense attorneys come across a number of things that would be, Brady Giglio violations, but might not be in the official system, right? That law enforcement is determining and prosecuting. So if you were us, I'm curious what you would do to try to collect that information so that we could include it in the public database.
I think there's a number of sources I kind of alluded to.
You want to do that?
Yeah. I think, one thing that comes to my mind is develop a relationship with the public defender's office.
Good idea.
They frankly are the key to defense in Cuyahoga County. The public defenders are given a bad rap, but our county defenders are good. And they're conscientious. So set up a meeting with them or whatever and say, look, if this is a matter that's not confidential or privileged, do you have any record of any bad conduct or falsification or any misconduct of an officer that's involved in their case? Tell us about it and we can track it down or get the evidence from them, okay? Because they'll have it. The broader criminal defense community is pretty, diverse. And there is a Cuyahoga Criminal Defense Lawyers Association that's been going on for how long? 40, 50 years. I don't know what they're doing at this point, but you may want to reach them and say, huh? Okay, and so that's, and then, but the hard work is getting all the records and making sense of them. And, it's tedious, it takes time, but this is you're in the infantile state of this group. You're learning how to deal with it. It's a complicated situation. I envy you for doing this, but you have resources to get people to maybe put that data into a platform of some sort.
Wow, thanks. I would say the Public Defender's Office is a great idea. And Erica Cunliffe, who is the head of the appellate section there, sees a lot of this information coming through. So she would be also a person to sit down with. And the head of the Public Defender's Office, Colin Sweeney, is excellent and actually served on the search and seizure committee that I ran, work group that I ran. So he will be more than willing to cooperate and get law students. I mean, there are law students that are trying to figure out what to do with their lives that would be happy to volunteer to help you to go through information in documents in red flag situations where appropriate. And Cleveland State, I think, is excellent. I'm biased because I teach there, but Case Western is terrific. I'm a fellow commission member of mine, Lou Katz, is still connected with Cleveland or Case Western. It's kind of in a retired position, but he would be a great resource for you to contact, as Jason can attest. Yes, Madam
Okay,
Bickerstaff.
I'm gonna put it out there.
Put it out there.
Cut, okay, no, you can hear me.
She never needs a microphone.
We have to.
Okay. I disagree with you
You do?
about Erica Cutlip. No, not at all.
Okay.
Cullen Sweeney, yes.
Your judgment,
That's the truth. Erica Cutlip, I'm working on wrongful conviction now, several of them, where she knew the officers was wrong and she wouldn't do anything about it. So absolutely not. Now you can listen to them, and you can because they're lawyers, but I've been doing my job for almost 20 years, and I've had a cop fired before, and I deal with dirty cops every day. So you want to go to Cullen Sweeney will be your best person.
All right.
Okay? I gotta say that.
Yeah, I wouldn't argue.
Thank you.
Richard,
Okay.
you're sitting back there quiet. Let me hear that.
Sure, I have a question.
Yeah, I mean, you're sitting there and you're probably the most experienced person in the room. Having been a police officer, an investigator, and a former member of the same commission that I served on.
Yes. Actually, my question to you
Wait,
guys.
that's first.
So thank you guys for coming, appreciate it. Quick question. I'd like to know how you guys view paragraph 19 of the consent decree as it relates to the commission having the authority to request whatever documents from the city, and that the city is supposed to abide by that and give it to them.
Well, we did that dance. Yeah, go ahead, Jason.
Okay, I just want to make, there's a couple of misinformation things floating around, so if I could please just make a point real quick. First, we no longer have to do public records requests. 115 gives us far more power than that, so we do not make public records requests. We make requests as the commission to the city of Cleveland, and they have to, they're supposed to follow the rule of 115, which is to produce documents unless they're part of an investigation or excluded under Ohio law as privileged for law enforcement. So we have very broad power to access whatever we need to. It is not the same, and even trumps paragraph 19 in the consent decree, which was more of a gentleman's agreement that had to go all the way to Judge Solomon Oliver to make a ruling. And so even if we default to that, Judge Oliver has put timelines on all of our requests in a specific procedure as long as the consent decree is in town. So just so people are aware, we can be resisted for asking for information. There are some affirmative defenses why they can't give us that information, but most of our requests under the law is on our side with 115.5 right now. So we stand on solid ground in that. The second point is the rule we passed, since we didn't read it, does not say that just the only thing we're doing is asking for letters from the prosecutor and letting it stop. What people need to realize is the consent decree has changed, and they put something in there that's not in writing, but the DOJ has mandated. The Division of Police has to create their own integrity policy, right? So now that Brady is on the table and integrity is on the table, they have to tell the DOJ how they manage this internally. They don't have a policy to create a list or do any of that stuff or communicate formally with the prosecutor's office, as we learned. So where we sit now is we can go and tell them what to do, right? But it's been made points by your colleague Aisha Hardaway that doesn't cause organizational learning, right? What we need to do is stand back and let them make an attempt to do the right thing and produce a great integrity policy, and then we build off of that. There are other sources, no doubt. But what I often ask attorneys is this: if you've been long-term witnesses of misconduct, why do so few attorneys, even public defenders, when they see something wrong, how come they're not going to OPS and filing complaints about it? So that's my call to attorneys is go to OPS and put it on the record.
Because historically, because the answer to your question is, for at least some attorneys, is that OPS has been totally unresponsive to complaints and have been backlogged with millions or thousands or hundreds of cases.
If you want it on the record, though, that's where it goes.
Well, it may go there, but it's going to sit and collect dust.
Well, you know, when we get a client that has a potential claim, we often send them over to OPS just to make a record, if nothing else. And I think it's a new world now in police accountability that did not exist even 10, 20 years ago.
Or even 5
And
years
I think
ago.
people are more open-minded. So we got to get to these attorneys who only care about their own practices or whatever, and don't have a larger picture of the community needs. And that's why I'm suggesting to talk to these organizations and press them to cooperate with the commission unless there's a reason not to because of confidentiality, et cetera. So I think the sky's the limit as to where this information can come from.
I mean, you all have so much authority and so much power and authority to really actually bring about change. And that's a heavy responsibility. And, you know, I salute you for it, but please don't sit on it.
So much. Are there any other questions?
Yeah.
Brenda,
Yeah,
Get the last word, Brenda.
yes, I am. Read the consent decree. Read Charter 115. I'm gonna keep saying this until I can't say it anymore. When we were doing issue 24, we had to memorize all 16 pages of the petition because people was asking questions. This is on page 8. So-and-so's on page 15. This on page 2. This is how we had to answer those questions. Read. Some people, from my understanding, are saying they don't have time. When they were interviewed and we were there, Joe Jones asked them, your time, what do you have enough time to do this for attention and retention? And I'm going to keep saying it. You have to read this in order to be successful. You are powerful. You are powerful. You're the most powerful commission in the country. Please do that. Read.
Amen.
Thank you so much. I did have one question, and thank you always for the reminder to read the consent decree, despite what Luke Katz told us, I think, because he has a body of knowledge that he may need to read less than us. I had a question. So it does seem there were a few other things that I heard in your presentation, Mr. Gilbert, of potential places like public. Is it from a judge docket you mentioned? Are there other spaces with which we can get this information that may not go through an organization?
Not so much in the docket, because those are just official entries by the court and papers filed by.
Right.
But, you know, it's hard to be a watchdog over what goes on in the courts, obviously. So that's why I'm saying, you know, reach out. I mean, you know, make sure you get the complaints that are filed to the OPS. Share information with them on current cases or past cases.
So this is of civil complaints.
Yes.
and you may also, as a resource, it's not a direct resource, but a supplemental resource, is contact the Ohio Public Defender Commission, which is an outstanding office and does a great deal of research throughout the state. And at least you should let them know who you are, what you are, and what you're doing. And I think it's a terrific office. I don't know what Brenda might say, but I think it's a terrific office.
Yeah, and because just quickly, because this is a community police commission and you're beholden to the community, have a session with the community. Invite people who may have complaints, just so they know that you're listening to them, and you know, and direct them to where those complaints should go and how they should fill out the papers and things like that.
Or even walk them through. Have
I mean,
advocates that walk them through.
I can't tell you how many people, you know, through either my criminal defense work or civil rights, say, I don't want to go down there. It's bull. You know, we don't get anywhere. They make us feel like we're victims, and they cross-examine us at the interviews, things like that. So maybe that's a thing you can put together.
So as a follow-up question, Jason, what is the duration that we are now attempting to wait for the city to develop its own processes?
So as Gordon knows, the consent decree policy process is slow. So here's how it works, and this is the long answer to an easy question, is we don't have a time on it. It's slated to be done. You heard the city say that they are going to work on it, right? But they can't just produce something and throw it out. It has to go to the DOJ, it has to go to the monitor for comment period before it comes back. And we will probably interject in that process too as a draft. So it depends on how fast and how busy people are and how many comments come back and how many meetings have to be had. So they don't have a timeline on it. But I don't anticipate it will take longer than our first year, you know. And if it does, it's not like we can't check in on it or press on it, you know. And as Mr. Gilbert mentioned, there are other sources. But first, we have to see what they say they're going to do and then improve what they say they're going to do. If we have to use our authority to make it better, we can do so. But that's what we hold them against. So first they need some rules for us before we could say, you know, right now there is no rules. We saw even the prosecutor doesn't have a firm set of rules of how they handle it. So that's the confusing thing about it. The prosecutor's mandated to do this under the law, and they don't even have rules of the road for how to do it, or their rules are quote unquote in review, right? So we're, as he mentioned, it's a complex area, right? And so my recommendation is we work in unison to try and come up with a region-wide solution for this issue, because if we rush forward too fast, when you were at OPS, you can see we can result in a lawsuit. There have been defamation lawsuits. So let's say we put, and I can put this question to you, right? If we rush ahead of everyone else's standard and create our own standard for what's Brady, right? We have to be very careful that we're on solid ground, or else that officer can sue us for defamation. So, and that can hold this process up even longer. So I'm not saying we don't come up with standards. What I'm saying is we have to be strategic, we have to be thoughtful, we have to look at a lot of sources and get a lot of feedback before we write a rule about how exactly we do this.
But you can't be too patient.
Yeah, so that was my,
right?
this
Well,
is.
I mean, you know, obviously you have to be cautious about information that makes allegations against somebody in any context. But what I'm saying, you could work to get matters that are public record, whether it's from a case in criminal court, or whether it's through prior actual disciplinary findings where there's no dispute that it happened unless it was overturned by a court or something. And you have to have terms to do that and to be cautious about it.
So I will get you, Commissioner Ridgeway. I just wanted to say, so my concern personally is that records, they're physical or digital, they take time to arrive from place to place. They take time to request. There's a lot of things points of waiting in this process. And I would be fine with developing a parallel process that takes the public records information. This could be voluminous, right? We now know it's voluminous. And my concern I don't know exactly what time we gave them to develop a process. However, if you say that it's taking no more than a year, I would like Mr. Gilbert and Mr. Friedman to describe to us what could happen in that year if there was a case. And basically, I'm asking you to describe what happens if the exculpatory evidence wasn't found, it wasn't given by the prosecutor, wasn't found during discovery, the person ends up in jail. What is the reversal of that? If you walk us through all of those steps.
That's
How many times do you recall in your experience, Mr. Gilbert, being the recipient of exculpatory material from the state of Ohio? How many instances do you recall?
I think one time.
In how many years?
Close to 50.
There you go.
I hate to say it.
I think that's the answer to the question. It gets lost.
Well, prosecutors often give you, prior statements by witnesses, where there's inconsistent statements, they have to produce that. That's exculpatory. But in terms of police, it's a whole different ballgame.
I mean, if you have a witness that says that guy was not the guy that committed the crime, this guy was, chances are you're not gonna get that police officer's statement. I wish you would, but our experience is that you're not going to.
And usually it comes about through post-conviction motions for trial. and
Habeas
so on.
corpus.
And you find records that were never disclosed. That's the usual process.
Yeah, so I guess my point is that, you know, it may seem like, we're looking at the macro scale of what we have to do. We do have to be aware that single individual lives are at stake.
They're in jail.
And, yeah, and they're in jail, and we have to be careful how many we're willing to, how much longer we're willing to wait, how many of those people are willing to sacrifice, because it sounds like a very long process to even get them a new trial and get them the justice that they may deserve. So that is my
That's
concern.
why I'm suggesting that what exists now, you should get. That's
Right.
all.
Okay,
And I
great.
agree, but keep in mind the other, as Jason said, keep in mind the other sources that can be tapped into.
Thank you so much. So Commissioner Ridgeway, and welcome to Commissioner Van Leer. If you would like to participate with any questions, please do.
I just wanted to add, if I'm not mistaken, these are the same issues that we were discussing when we were under 2.2 flow of information, when we were trying to develop our rules that related to that particular issue. And we actually asked that questions of some of the other guests who came. And we do know that a lot of those processes were not in place. And I remember questioning, how do we define that in terms of our rules, in terms of how quickly we can get that information? And I remember we were gonna leave it open. We were gonna say something like until something. Do you remember that under 2.2 on the flow of information? So I think we are aware that we don't have access to that information, but in some of these instances, the information must come from them to us. And so I was trying to press to make sure we were able to receive that in a timely manner. But I think we left the rule pretty open. Was it 90 days or until? It was a year? Well,
Depending on what's coming up about that policy with,
under 2.2 on the floor of information, yeah.
but we did send a message to, Terry Howard to receive, to start to receive some of this information. So we have started doing our due diligence.
No chair microphone.
Thank you. So I did want our guests as well as our public to know that an email was sent to request the information that is on file. As you can imagine, because there aren't processes in place, that getting the information is going to take a little while. But as of now, there hasn't been any resistance, but we are in the process.
The resistance will not appear as resistance. It'll be benign.
Yes. Thank you. That's true.
So I'm aware of that. We did submit an email, so we will follow up if any additional requests are needed.
Good.
However, I did want to say I was going to make a similar request, and if I did not, none of the other commissioners, to my knowledge, knew about this request. So I request that all of the commissioners, especially the Rules Committee, be told about anything regarding the rules. This was a process that we're trying to, Jason and I had already talked about, that we would request from Carrie Howard. So I'm asking for a little
So
bit
the
of.
email was sent from Executive Director Jason. So I'm unsure of who he included, but I am aware that that email was sent.
Okay, thank you so much. Mr. Van Leer, welcome. Do you have any questions at this point?
No.
Thank you so much. Do we have any more questions? Not to put it on you, but you seem to, and because of your experience, you can anticipate forms of passive or resistance or subtle things. What would you recommend as reasonable time for us to allow these potential growth periods and teaching moments for the city, and in a non-cynical way, you know, that would be that would not be damaging to anybody that has pending cases, or.
Well, it's a broad question. I think that, once again, there has to be some record, reliable record of the violation, okay? And like I said, the only way you can do it, aside from their own admissions, the prosecutor office, is to look at these other sources. And, you know, just wade through all the prior discipline. I don't know what else to say about that. This is all new to me, so in terms of this body, I mean, I know what I do in my cases. And some lawyers will share public records.
I would say 90 days.
90 days, okay.
Yeah, I would say 90 days at the most,
I mean,
and,
to get the records.
yeah.
No, that's, they know what computers are, sorry.
But I also would suggest contacting the Cuyahoga County Criminal Defense lawyers are not, it's not a very progressive organization. It's reactionary, actually. But you may want to make contact with them to, if any lawyers in that group want to complain about not getting exculpatory information, that'd be useful.
Okay, thank you. And I don't know if it's too provocative a question. Is there information on officers that you are able to give us from Gilbert and Friedman?
It's actually Friedman.
Gilbert.
Gilbert.
Gerhard, see.
And
Gerhard.
I'm actually not an active part of the law firm. And I'm kind of retired, so to speak.
But you're a founding partner, so.
Sorry,
Well,
I
I
say.
was a founding partner, yeah.
You are.
Gilbert and Sullivan is true. They were a good outfit. No, I mean,
I mean, yeah, I have to admit that I have not kept track of all the cases over the years and made a file of discipline. And I regret that I didn't do that, frankly, but it's a tedious thing and it's a small office. So we only looked at each case that we had. We didn't go back. Sometimes we get information. I can mention one, and I don't know if I can mention one person, but I won't do it on the record.
Mm-hmm.
That you might know about that is undergoing review by the OPS.
Mm-hmm.
And there is a track record of this person who's a detective creating false search warrants.
yeah, I know of that as well.
Okay. You know where I'm talking about.
I do.
Okay.
But, you know, I would always also say that, again, in the 50 years that I practiced law as a criminal defense attorney, I do not have a recollection of a state Cuyahoga County prosecutor coming up to me and handing me a statement and saying, this is exculpatory evidence. We have an obligation to provide you that. That never has happened. Maybe it never existed, but it's never happened in my experience.
Can I just make another point of clarification?
Sure, Mr. Gilbert?
Two things, I'll use this one. Two things that are confusing to the public when we have this conversation. One, discipline does not mean that you appear on a Brady Giglio list. So all discipline that officers receive does not mean that you are, you have an issue as a witness in the court of law. So there is confusion there because we mention it a lot that all we need is a discipline list. What there isn't is a standard. So this is where I'm going back to it, right? So there's court cases that say this should be the standard, but there is no national standard. There is no written standard that I've ever seen that says, if you have this discipline, it automatically puts you on it, right? So except for very few clear instances like truthfulness. So that's one point, is that we don't have a standard to follow, so we have to be careful when we create our own. The next one is there's some confusion about courtroom behavior versus our behavior, right? So we don't have authority to intervene in courtroom behavior. So when they talk about not getting evidence, it doesn't mean that it was 100% the fault of the division of police or one particular officer. What it means is the prosecutors are not doing their job. So even to your point about lives at stake, the creation of our list does not necessarily mean in any way, shape, or form that will help with a case, because if the attorneys are doing their due diligence and following the law in place, that stuff should be being revealed. So it's not going to prevent prosecutorial misconduct. It's not going to prevent arguing that our list is valid, right? So prosecutors, at the end of the day, when Brady Giglio came about are not doing their job, or else we would have this list, right? These would exist, so they don't exist for a reason, but we can't interfere in courtroom procedure. We are not involved in if a prosecutor doesn't do their due diligence and provide that to the defense attorneys. Can we help in some way? Yes, but I don't feel that that impression is correct, that we will impact lives if we don't immediately create this list, because it's the prosecutors that are doing that at the end of the day.
Yeah, I mean, that, I'm not sure I agree with you, Jason, if I may, but disagree with you. Maybe I don't. This is shocking recommendation to you in terms of a resource for information on standards for the police, and in particular for the prosecution. And I can't believe I'm saying this, but I would recommend examining the ABA standards for the criminal defense and prosecution in criminal cases, because those are standards that are laid out specifically, and not a bad, once you read the consent decree, if you haven't read it, and once you read the charter amendment, if you haven't read it, then I would recommend taking a look at the ABA standards in criminal justice, the role of the prosecution, and the role of the defense in both sides. It's homework that you should engage in. Yes, ma'am.
Benito.
So this is more of a question.
What's our time like? Are we over? Over?
We have 10 minutes.
We have 10 minutes. It's like a game show. Go ahead.
This is more of a question kind of for us as a committee. But so in looking at what we have so far for section 2.7, which is where where it lays out what the rules are for the Brady Giglio list. Right now we pretty much, the part that says what we will do, the first part of the policy is just background on what the Brady Giglio list is, but it says that the commission shall at minimum obtain copies of these letters, meaning the letters that are sent between the Division of Police and Prosecutors Offices, and make them available to the public as mandated under Charter 115.5. The commission staff shall also monitor all discipline notices for evidence of officers who are alleged to engage in behavior arguable for inclusion on a Brady Giglio list. Within 180 days, oops, it just closed on my computer. On my hand computer, aka my phone. Okay. Now I got it right here. Okay. Within 180 days of adoption of these procedures, the commission shall work with the division to develop an internal policy on managing the Brady Giglio material and a process to ensure that the public's mandate in Charter 115 is met. This work shall be done via committee determined by the co-chairs. So that is what Jason was referring to when he was talking about
Point of corrections.
clarifications.
Yeah,
Sure.
you're reading from an older draft.
Yeah, I don't think we've been sent the newer draft, have we?
We have as an adopted rule, and that draft, this draft just has the rule will be revisited. It has no time when the Cleveland Division of Police creates its integrity policy as mandated in the consent decree, or if the creation of said policy exceeds 1 year from the adoption.
Okay.
So I guess it's a 1 year.
My understanding was that we did not adopt Rule 2.7
We
in
did
the full
adopt
commission.
2.7. We did not adopt 2.8.
What's 2.x?
Well, the numbers will change. So
I
it's
thought
Brady
we were
Giglio.
waiting to adopt it until we.
I think that the language that you just shared is adopted.
That was adopted by the full commission.
So the chair was adopted on 4/12.
On 4/12.
By the full commission.
By
I
the
thought
full
we.
commission.
I thought we were waiting to do it until we.
No, we're doing singly, and the one that we did not adopt is the one we're talking about, which is the public speaking commentary and media relations. It was a set of three. We adopted the budget, and we adopted the Brady Giglio rule.
Right. Well,
Okay.
so I guess my question is, when we've been doing all of this additional discussion on Brady Giglio, which you've done in 2 subsequent meetings after the adoption, then
Well,
why are we talking about going back to
we
2.7?
could amend anything, and also Mr. Friedman and Mr. Gilbert were scheduled earlier but we moved them because of, the city prosecutor.
Right, but even that meeting was after, so I guess my question is, because the question that I was gonna ask is, do we need to amend, because right now all we're talking about is the receiving of letters that are going back and forth between the prosecutor's office and law enforcement, and I think that there's some real strategic questions that we need to ask ourselves in terms of if we go further than that. And in some ways, I think that it becomes a question that should be bigger than I think just the Rules Committee. Because I think of what we're doing as a procedural,
Well, it will go to the full commission
Right.
once we approve it. So
Right.
perhaps we can ask, because Mr. Friedman and Mr. Gilbert have read our standing rule.
I'm
Do you-
still,
Oh, sorry, go ahead.
thank you. So I think that when it comes to deciding whether to go further than that, my question is, are we going to go back and revisit that? Or are you saying let's revisit it in a year with the rules? Because, we just are having a lot of discussion about this, but especially, I'm sorry that I blacked out when, I know I voted for it in the full commission meeting, but, what are we doing with this information now? Are we planning to revisit that? I also think that there's merits to both trying to push further than what we've already adopted. I also think there's some real potential threats, potentially, of if, I think like Jason is laying out about, potential defamation lawsuits or, just that it not being the most strategic thing for us to do first.
Are you insured?
We're indemnified by the city, I believe.
So that's my question for us as a whole, is are we revisiting this policy?
However, I do want to clarify that Mr. Gilbert said that these are public records, and we are trying to we're looking at the records first that have already been affirmed by other sources. So,
I don't understand the relevance.
meaning that either a judge has decided this or a prosecutor has decided this. I don't think we're
Or
initiating.
the city,
Yeah, the city,
or the
some-
safety director.
Or the safety.
Well, I'm just saying what 2.7 says, which is right now the rules that we have created as a commission that relate to this process.
I understand. So, would you like to put a question to Mr. Gilbert and Friedman about their advice?
To us about whether
I-
we are revisiting this rule.
Personally would like a parallel process that protects us from, indemnifies us against potential defamation. I think that's easy to do. And, but I do, for the sake of, the lives I know he doesn't like that, but for just the sake of a parallel, we're gonna have to do a parallel process, it seems like, ideal, because we have to audit, right? It doesn't matter, how well the information comes to us. We have the responsibility to make sure that process, that list is, substantive and accurate to the best of our ability. So I don't see a reason why we can't start a parallel process. Now, especially because it seems like there's a lot of paperwork to go through. So
So you're talking about revising 2.7 to create a parallel process.
we could, yes. And I was going to ask Mr. Freeman Gilbert, after reading 2.7, what they may advise us to do with that rule, if we don't have to adopt exactly what you say.
I'd have to give it
I
more,
have no opinion at this
yeah,
time.
I have no, I'm not
Lawyers.
a rules kind of guy.
No, just
That's fair, I know.
pragmatist.
But I will say,
You will say.
maybe I get the last word, but
Have those-
the one I'm reading now from April 12th, 210, Brady Giglio is a legal obligation under the Constitution, but you're not necessarily bound by the Constitution here. That's just the start, because you also say here, that managing a list of Cleveland Division of Police officers who may qualify due to past history and behavior, potential material affecting officers. That's a bit broader. Okay, and you have things like drug and alcohol addiction, driving on, a whole range of different things that are not technically Brady Giglio, okay, but they lead to the effective impeachment of an officer in a criminal case for the prosecutors and the defense lawyers, but also it assists you in red flagging, okay, and it's so if I was writing the charter, I would say, I would list the whole,
You'd love to write it.
I would have listed more than Brady and Giglio, but that's the way it is.
Yeah, I don't have a comment on rewriting that particular motion, but I would let you know that silence is also exculpatory. And it is not well known. And again, that's in Jones v. Jago, and a decision decided by Frank Battisti, that a witness failure and not mentioning a party at a shooting is exculpatory. So it's pretty subtle, nuanced stuff out there. So beware.
That's okay. You got the last word.
I got the last word.
So we have,
Rare.
we are, so, okay, we have 1 minute. Let's have Rosie's question very quickly and very quick response. Since we started at 6:14.
Hi. So I just wanted to mention, I don't know if people are aware that with the Tanisha Anderson case, the Ohio Bureau of Criminal Investigation did these are all public records online. They were forced to do the investigation because Garrity material was turned over to the prosecutor's office. They had to get a special prosecutor. They had to get a taint team to come in. And then it was a mess. It dragged on for 2 years. The original autopsy report was thrown out. They had to do another autopsy. We'll never know what could have happened had that not happened. And Mike DeWine was I believe he was the attorney general at the time. He wrote a very scathing letter with the investigation. And here's my concern. That has never been addressed by the city or the county. As to what was in that Garrity material, people can only make assumptions. And how do you prevent it from happening again? Does that make sense? Because this family may not have gotten justice because somebody made a mistake. So I don't know if there's any advice.
I think dealing with Garrity is a totally different
Discussion.
animal and
Okay.
discussion.
I
And
just wanted to bring it up.
you're totally right.
Thank you so much.
Yeah.
Thank you so much.
Thank you.
Thank you so much. We are on time. Thank you, Mr. Friedman and Mr.
We did our
Gilbert.
time.
Yeah, we did it on time.
Thank you for inviting us.
Thank you.
Is this your contact information here?
These are your, the bios, you could like.
I'm at 216. I'm not with him anymore. I'm 216-375-1289.
1289?
Yeah, and I answer all calls, including from Brenda, right?
Thank you so
And
much.
I'm 1288. We got the numbers.
Wait,
at the same
really?
You
time.
guys, have you ever wanted to perform in a legal comedy troupe?
No, but we've been in many trials that
Seem like a-
suggested, yeah.
It's like a marriage, you know,
Just a
you got ups and downs.
Terry, it's time to say goodnight.
Okay, thank you so much.
You guys.
Thank you everyone for your questions. We will now move on to new business. And the first order of business is an amendment to our existing bylaws under 1.4.4 under leadership. This is an amendment to change the voting powers of ex officio committee members. Mr. Goodrich, would you please read the additional amendment? Hold on. So we are going to only read, this is, if you can go over generally what this, for our audience that doesn't have the bylaws, this general, section and the amendment. Thank you.
Okay, so, come on. This is a rule that was previously passed, 1.4.4. It deals with leadership and the roles of the co-chairs. At the time it was passed with the word ex officio in there, and since it has been identified that some of the rules governing ex officio need to be clarified in our bylaws. So in an attempt to do that, we are adding the language to 1.44, which defines ex officio for co-chairs, is defined in these rules as co-chairs have the right to attend and speak as if they are a committee member at all committee meetings, except meetings dealing with nominations or elections of co-chairs. Attendance is discretionary. Co-chairs cannot introduce motions or vote in committee meetings, and co-chairs do not count in the number for determining a quorum or whether a quorum is present.
Thank you so much. Is there any discussion or amendments to this? Have we all had a chance to process this information? One problem.
Yeah, it needs to clarify that they don't count as a quorum in the committee.
Okay.
Because otherwise we'll limit in the meeting. So.
Okay, we could put that in. So this is to address the issue because as we see, we have 7 people here. Not only do we want to balance the powers between the co-chairs and the rest of the committee work, we also want to prevent the likely occurrence of a majority quorum and a unanimous vote, circumventing the ability of the full commission to be able to vote on a matter. Thank you. Commissioner Ridgeway?
Yeah, just a question. So, when, I'm gonna say when this is approved, not if this is approved, but when this is approved, remind us of the timeline for implementation. So 15 days from the point that it's approved at the full commission meeting, or
Is that for amendment also?
It is for
Mhm.
So I can read
I
it.
just wanted him to read it.
Yeah, I can read it. So this will not take effect immediately. But we do have to be careful even with the vote for this because it has to be read here, voted on here prior to the amendment being introduced to the full commission. Once it advances from here, for the initial adoption of a manual and the adoption of any proposed amendment to the manual to become effective, 2/3 of the permanent members, 9 out of 13, must vote in favor. If they do, with the exception of the first adoption of rules, which we've already had on this, which will take effect immediately, any subsequent rule changes in the manual will take effect 15 days after their publication in the official minutes of the meeting. So the minutes will be published and then it's 15
This
days.
is, we're speaking of the minutes of the full commission. Okay.
So are we clear about that? Is there any further changes that we want to make or clarifications from any person? So we do have to be careful because we have a majority quorum here. Would anybody like to make a motion to add this amendment to our rules
I move to add the amendment to our rules.
as written? Okay. Is there a
As written.
second? So is there any more discussion? No? Okay. Then we will move it to a roll call vote. I guess I will go last. Commissioner Benito,
Aye.
Commissioner Donaldson,
Aye.
Commissioner Van Leer,
Aye.
Commissioner Zayed,
Aye.
Commissioner Ridgeway,
Aye.
Commissioner Rodriguez.
I abstain.
Okay, and so therefore I can vote, then I will vote yes. So the motion passes and it will be moved onto their full commission meeting for adoption. Thank you so much. Is there a discussion here?
So I was trying to see, never mind, we'll talk to Jason about it afterwards.
Okay, thank you so much. Now we will move to old business. It involves the continued discussion of our administrative procedures, which is section 2. And this exact, rule has been moved back to committee. We had extensive discussion previously about it. It is now right now 2.8 about public speaking commentary and media relations. To remind our audience, the point of contention is how do we deal with complex or dissenting opinions among the commissioners and whether certain types of documents that we publish will contain all of the signatures of the commissioners. I hope that is the only point of discussion. So I realized that Mr. Van Leer had added some language to help clarify the types of documents and the signatures that would be required with those documents. Can we scroll to that? And also,
Well, so I don't have, your newest edition, so.
and I
I'm
made an
missing
addendum to,
your addendum, so I could
to-
show Pete's, suggestion, Commissioner, Van Leer's suggestion, but I cannot show yours. I do not have.
okay, let me just, I need to email it, right? Okay,
The
so
newest version.
I'm gonna email the whole thing.
So it includes
Both.
Commissioner.
Yes, it includes both. Please bear with us, thank you. How'd I send it to you already?
You sent it before.
So yeah, I sent an email on May 1st to everybody
Right.
in this room at this table. And I would love to make a motion to adopt what I sent.
Well, we have
So,
this
I'll wait.
other,
I haven't seen what you're talking about.
yeah, I'm sorry. I was thinking, and I do want to make it very clear on the record, whatever I've added was to ensure a substantive discussion of whatever issues that the documents contain. I am increasingly concerned that we are moving too quickly in a kind of majoritarian type of way. There could, lots of the issues that we are dealing with as a commission are gray. So I do not believe a black and white kind of procedure with the signatures and with the contents of the document serves and is able to
Can you
fully
resend that?
embrace it. I just sent it. What?
Well, she has something that she would like us to review, so we
It
have
didn't come yet, so.
because I think it's based off what he said, so.
It's just.
Oh,
it's
you
not-
sent it to a different email.
Oh, no.
All right, here we go.
So the top, if we want to read, is Commissioner Van Leer, and the bottom is me. And this is my attempt at a compromise. Let's please embrace
Can I
this with
forward,
open
I'm
mind.
gonna forward this to
everybody,
everybody so they
okay.
can look on their screens as well, so. First I have to send it to my, this. So just bear with us for a moment. As soon as it comes. People who want to look at it can look at it, they don't have to look up here. In the meantime, you can start reading it.
Is someone gonna read the relevant portion?
Yes.
We will.
Okay, thank you.
Don't you read?
Why?
Do you want to read?
I mean, it doesn't matter.
All right, so while it's being sent, so this is additional language that, replacing the sentence that was controversial regarding written reports that was previously, sent back.
What's replacing?
So what it's replacing is the original controversial, sentence was written reports and statements approved by the majority of the commission shall include the names and or signatures of all commissioners regardless of their vote. So that's the original language that was proposed and was tabled at the last meeting, or 2 meetings ago. Now, going back to here, the suggested change to it is all written statements and reports having been publicly discussed and voted upon by members of the commission as stipulated in the commission's bylaws shall be understood to represent the commission as a whole. Reports shall contain only the names of the individuals, including commissioners who contributed to the work. Letters or statements voted on at a full commission meeting shall contain the names and or signatures of all commissioners. Press releases shall be identified as originating from and representing the Cleveland Community Police Commission. This, that was the part that was submitted by Commissioner Van Leer. This next addition was made by Chair Wang. In order to promote clear and thoughtful communication, every reasonable effort will be made to ensure that the aforementioned documents contain sufficient discussion and consideration of the issues and perspectives contained therein. No written document will be hurried toward publication without a final check and a majority veto on factual inaccuracy, rhetorical excess, and other errors in reasoning. As a working guideline, authors of all documents shall seek to enact the balance of logos, ethos, pathos, logic, ethics, and emotion in their writing. This guide is meant to strengthen the impact of CPC communications and publications.
Thank you, Mr. Goodrick. So we're open for discussion. If there's any amendments, it's just basically a mashup. This was,
I still have not seen, is it coming through?
I'm gonna send it
Okay.
right now.
Because I really need to read that.
Mr. Donaldson?
Yeah, so my initial concern, I guess, or thought about it is that so if Pete sent his thoughts on Monday, I just don't think it's fair for us to then add your additional language and then consider that as a whole. I thought I was under the impression that we were going to be talking about Pete's suggestions. So with yours added to Pete's, to me, I just don't know how Pete would even feel about that. So
I do want to note that I did respond to Pete's email right away. I apologize. I mean, my delay in authoring this is because I think it's a complex matter. So I sent it. I don't see any reason, unless there's in Robert's rules that something can't be, because we're amending things as is right now. If we need to take a little bit more time to think about this, I guess we can table this matter. I don't think people want to.
So just so I'm clear, we are to consider that, I know there's not a motion, but we're talking about the entire verbiage, including yours and Pete's, or are we talking about Pete's
Yes, I would
verbiage alone?
I would like for it to be considered. I see no controversy, because a lot of what I wrote in the last paragraphs are already said in a different way in the top, but I just wanted to make it fair. This is not about, I just to give you my reasoning and my thought process, because that night, to be honest, if we had moved it to a full motion, I probably would have voted for just, to carry that rule. However, the more I thought about it, I felt that we cannot we need to make rules for our eventual mission, rather than making rules in reaction to potential things that either are speculative or internal to our commission, or even external, like the police. I have to go on record that I think, if I can speak for him, I will ask him, Mr. Gilbert, do you see any legal problem, legal liability with including, even concluding a dissenting opinion? Is there, to make it easier for people to understand?
So for the record, I'm not a attorney or counsel. So if you're asking a legal question, we have to forward that to the law department.
I did speak to a few attorneys. We probably should ask Mr. Friedman and Mr. Gilbert for their opinion, and they saw no legal liability. You are free to go out and find, from the law department. My concern is increasingly, not just with our publications, which we don't know exactly what will happen, but increasingly with behavior. And for example, I know I was not present at the last meeting. However, I did not even know anything was on the motion for Jason's extension of his tenure. And my concern is, it is a little bit internal, but it's trying to help us fulfill our mission. And I believe our mission is, as 13 people, to represent in some ways the community.
Yeah, I understand that.
I'm not finished. And let's think about the long-term goal here. If our desire is to bridge something between the community and the police and all the entities, we might not exactly represent 13 opinions there, but there is a diversity of opinions there, and there's going to be for our most controversial issues, which is investigations. To me, a stronger argument embraces some of the concerns of the community. Maybe not in a full dissenting paragraph. I don't think we need to go to the point of becoming the Supreme Court. And the Supreme Court, quite honestly, is very divisive. So I understand. So my compromise was to make sure that we have substantive opinions expressed. My concern is that we are going very fast in writing things, in other things that we have done so far, very fast, going with what we are just given, rather than thinking through and these issues as a way of, representing what would go on in the community. So I yield. Thank you.
So I'll just make it clear what my concern is. My concern is that you took a commissioner's language and you added your thoughts onto that, and then that should be it. So I understand that.
I'm
So,
not asking.
point of
that.
order, so we're gonna vote this up or vote this down, and then we probably can go, to Commissioner Pete Van Lee. But no, what I'm saying, I think we should probably decide to put a motion on the floor instead of
Can I speak?
continue.
Can you turn off your mic?
Turn it
There-
down
I mean,
a little bit, turn it down.
To address Mr. Donaldson's concern, I understand this, but it was not meant to in any way cannibalize what Mr. Van Leer wrote. I responded right away that I did not feel that Mr. Van Leer's language, although it was very much appreciated, addressed the core issue that we had in the full commission, which was the presence of dissenting or contradictory or complex information. So it seems to me that we're just establishing rules and without giving any type of consideration to the minority view at this point.
I just also want to add that with the verbiage that you added, I'm not sure what hurried motion means. Like, that's too broad in my opinion.
Just for clarification, there is no motion on the table.
Right.
Anyone can take any part of this language and make a motion, full or the entire language. It can be changed, so there is currently no motion on the table to vote. A motion can be made for this whole thing or a portion of this. Chair, you have a request for.
I'm sorry, Mr. Van Leer.
Yeah, so, I guess my concerns with the added language are that, from my perspective, when I wrote and proposed, all written statements and reports having been publicly discussed and voted upon by members of the commission as stipulated in the commission's bylaws. That includes that there has been clear and thoughtful communication, reasonable effort to be made to discuss, right? So this is, I feel like in some ways this is redundant, and in some ways it gets into unclear language about a final check and majority on factual inaccuracy. So I would very much I would make a motion right now to accept the language as I first presented it. So the first 1, 2, 3, 4
So I do want
paragraphs. I would like to make that motion.
to, is there a second for the motion?
Second.
I do want to point out that the first rule that you written does not stipulate that the written communication will include that discussion. Is that your intent, Mr. Van Leer?
My statement says all written statements and reports having been publicly discussed and voted upon by members of the commission. I feel that includes clear and thoughtful communication, discussion, sufficient discussion. I mean, that's included in my statement. I don't think that paragraph, the first paragraph that you added,
I think
adds
that's not.
excuse me, that it adds anything to the language.
I do not, just as a person.
We haven't opened discussion yet, so there's a motion and a second,
There's a second.
and then
Let's
we
open
need
for
to open it for discussion.
And I just want to address that if that was your implication, I don't see it written there. Okay, would you like to make an amendment to add that, if that was your intention?
No, I would not. I believe it's included in my language.
Commissioner Ridgeway?
I guess I'm seeking clarification. So, Commissioner Van Leer, your May 1st memo that begins with a second paragraph, all written statements and reports having been publicly discussed. Okay, so where I see a potential conflict is between that paragraph and the next paragraph. Because in this one you say all written statements and reports, and then you come back and say reports shall contain only the names of the individuals. Whereas the first one, it says if it's been discussed and voted upon by members of the commission as stipulated in the commission's bylaws, they shall be understood to represent the commission as a whole. Then we come, so the second one, that's the one I need some clarification on.
Sure.
So that second paragraph, reports shall contain only the names of the individuals, including commissioners who contributed to the work. So those reports are different than the reports, or it's the second paragraph only referring to reports that have not been publicly discussed and voted upon.
No, I mean, the first paragraph refers to all the things we put out. So that second paragraph is based on, there's some other microphones, based on our other conversation about the past practice and assume the ongoing practice when reports are published, they include the names of those who, it's under the full commission, but it includes the names of those who've actually worked on it. So, for example, if Commissioner A has worked with a work group to publish a report, that report would list the commissioners who worked on it and other members of that work group who have worked on it, but it would still be coming from the commission.
The full commission.
And the whole commission would vote on that.
Okay.
Point of clarity, if I may. All right. So looking at a report, what this means is the report will say the Community Cleveland Police Commission. Every work that gets voted upon and put out in public says that, right? So it represents, after it's voted upon, everyone. But we only list names of work that comes out of committee, the commissioners who actually worked on it. So we don't put everybody's name in every report when it comes out of committee. That's never been a practice. It's whoever authored or worked on the report's names actually list, but it will say, Cleveland Community Police Commission all over the report because it's been voted on by the report. So it is understood that it's endorsed, if it's public, by the entire commission. So that's the difference between the first and the second paragraph.
Okay, I'm sorry. Go ahead. I just want to go back to Jason 1 minute, your comment. So, how is that second paragraph different than what we're currently doing?
It's different because if you didn't work on a report, your name isn't on it, but you're part of the commission, and it says, Cleveland Community Police Commission, so someone can look and see that you're associated with it, but it doesn't necessarily, and they'll look in the minutes and see that how you voted on a report, but if you didn't do the labor of the report, your specific name isn't included as an author or an editor or a contributor to the report.
If I may also, Co-Chair Ridgeway, in this language, we work.
I did want to point out just that there seems to be, as you say, some confusion, a lot of words explained. I just want to note that is not clear, in addition to whatever things that I had noted. Mr. Van Leer?
Yeah, so Co-Chair Ridgeway, in response to your question, this language is coming up because of the disagreement we had, the discussion we had at the full commission meeting, where there are questions about what does a report look like, what do statements look like. So this is an attempt and effort to really clarify that. And clearly, if there's some language to add to that section, I would be willing to entertain that. I do not believe that the paragraphs, Commissioner Wang, that you added do what needs to be done there to answer your question. So I'd be happy to entertain some language.
We're still discussing this as is, and Commissioner Benito.
I don't know, please correct me if I have my parliamentary procedure incorrect, but I would like to make a motion to amend the motion that says.
You can do, I'll look at it, so give me a moment. You can amend, you can do a friendly amendment in the process of creating, so it doesn't cancel the motion on the floor. So let me just look at the specific rules.
Okay, I'd like to offer a very friendly amendment, that the language on the second paragraph be changed to saying, report shall note. What I want to say is that only the commissioners who contributed to the work will be named as authors on reports, because I think that's when it says the report shall contain only the names. I mean, we're talking about listing them as authors or contributors, correct?
So would you like to say authors of reports?
I think what I
shall have their name on the.
Yeah.
So these are reports, as a point of clarification, these are committee reports, but they come from the whole commission too.
So clarification, it's like the report that we sent out over a month ago, if you look at it. So the problem with that is you can contribute even if you didn't write. So when we're looking at a work group, you're excluding the ability of a name of a commissioner who put ideas, thoughts into it, but didn't do the penning.
Oh, yeah, I'm
So,
happy to use
you
the
know-
word contributor instead.
Yeah, so
Yeah, so-
that's what it says now, contributed to the work, so.
Right, I'm trying to just clarify that the shall contain only the names, to clarify that reports shall have listed the names of commissioners who contributed to the report.
No, it has to be individuals because there are people in work groups that are not commissioners potentially. But I think you want only out, shall continue, just where the problem is only.
Well, I'm trying to address the concern that it feels like the two paragraphs are contradictory as raised by Co-Chair Ridgeway, and trying to clarify that. So Jason, I mean, if you.
So I just want to make a point. I think here we're way deeper into this than we need to be. This is describing a process that's been in place for 5 years. So we don't, there's no need to dive that deep into it, you know, and overly debate this. If a problem comes up, you guys are welcome to amend it. You know, based on my perspective, when I read this, I understand the author, who's Commissioner Van Leer's intent of it. And I don't think that it's going to be a controversial thing. It clarifies whose name goes on what and what happens when you vote on something. So, you know, that's my perspective on it, is that the language here is not going to be controversial when it comes to explaining the practice.
Great, I was just trying to offer a solution to a concern that was brought up.
Would you like to offer again? And I want to
I'm
point.
good.
Okay, I am actually, because there was a lot going on. Commissioner Ridgeway, would you be able to explain to me the contradiction you see again?
No, I don't see.
No, I don't see a contradiction after you explained it to me. And the question, and the question I raised to Jason was, I don't see a difference in what we were doing already, which you just said. So I understand that now. That's what I thought to begin with. You explain that, I understand you confirm that.
I mean, my understanding is that this means that there are two different sets of reports, sometimes overlapping. Is that what we're dealing with? I guess. Yeah. I mean, there are reports that are in the committee. Oh, I see, okay.
So I can go through the light process of how reports are generated, if that helps, so, yeah, okay.
So there's a motion.
So there are two
There's
reports.
a motion right now to vote this up or down. We have a second. Is discussion done?
Let's call for the vote.
Let's call, so who calls for the vote?
You do.
Oh, I do. I call for the vote. All right. Okay, we're going to take a roll call vote. Commissioner Benito.
Aye.
Commissioner Donaldson.
Oh, gosh.
I think he went to the
He stepped out.
All right, Commissioner, we'll come back to Commissioner Van Leer.
Aye.
Commissioner Zayed.
Aye.
Commissioner Ridgeway.
Aye.
Commissioner Rodriguez.
Abstain.
Commissioner Donaldson. I think, and I actually vote nay for the reasons given before, because I do not believe that it actually addresses the conflict that we will face in the full commission. I have no idea. So that it passes, so that we have 1, 2, 3, 4 ayes, 1 abstain, and 1 absent, 1 bathroom, and then we have 1 nay. Okay, so motion passes. Thank you so much. This will be introduced at the next meeting. Full commission. Okay, great. What time is it? Oh, look.
7:42.
Oh, look, do we want to go on to 2.1? Or do we feel that we can, is there a likelihood that we will finish? Or would we like to,
It passed. Or we did it without you.
Oh, she has the floor, you have the floor.
Commissioner Benito?
I think I think I would suggest that we set our next meetings
Okay,
and then
we do that.
adjourn.
I think it's a little much.
yeah.
I think we had a great,
Yeah, we did.
discussion, accomplishment. No hard feelings, anybody. This is just, we're exercising our votes and rights. So Commissioner Ridgeway.
I just want to make one comment.
Uh-huh.
I think it is important, especially if we're going to table this on the dissenting opinion.
We're not tabling.
We're not
It
tabling.
passed.
That passed.
Yeah.
Was that part of yours?
It was just
No,
one.
it was part of, it was only his pass, so there will be no addition from me for that rule. So that's what we were voting on, unless people didn't understand what we were voting on.
Well, I knew we were voting on the reports. I guess I missed that other piece. It's been a long week.
All right,
And a
so what do
difficult
we do
week,
now?
and I am having problems following. So,
Okay.
so,
So the
First four
rule,
paragraphs.
the rule
Uh-huh.
with Commissioner Van Leer's
Mhm.
additions will go forward to the full commission for vote, discussion, and approval.
okay, thank you. I just want to make sure, since that had come up in our last, 2 meetings ago.
Exactly.
And we had not brought a deciding opinion back to the full commission, that we were not gonna delay it another
Right.
month.
But-
So, 2 weeks.
This again is my concern about that we have not, and I would encourage us to actually, it's not accommodating dissent does not mean that we have to agree with them, but I do think that certain commissioners that believe this feel that this is not a very good practice of listening and cooperation. Information has been shared to me. So we will see what happens in the full commission meeting. It will require a 9 to 9, a 2/3 majority in order to pass this as a rule. All right, so we will move on now to our scheduling.
So, there you go.
If we have, my hope as the chair of this, I know that we were doing so well with, first. My hope is that we get everything, hopefully, not to rush us, but if we can accomplish the goal of getting section 2 as we have done before the weather becomes, very wondrous for us to travel, that would be great. And I think I hope to accommodate everyone's schedules. That would be a great accomplishment. What do we have after this, Jason?
We have nothing scheduled for your committee.
Oh, no, but what do we have, those evidentiary things? Is that later? Evidentiary hearings?
For the rules?
Yeah.
Yeah, we're not here. We have this whole front section, 1, 2, 3, 4, and 5. No, that's not this, that hasn't been drafted.
Our goal right now is to get through sections 2.1, 2.2, 2.3, 2.4. I think we have those left. I think that that's a good goal for next meeting, and that's what I will set the agenda to be, barring any other issues. So if we can have, we still have to pass it through full commission, so I would prefer to have those sections looked at by us and hopefully finalized for the committee. So the 24th, when is our next commission meeting?
The 24th.
20.
Asking if you.
I was asking if you wanted to try to have that approved for our full commission meeting on the 24th.
Yes, I would prefer that, and I think everybody else would. I'm hoping prefer that. Sorry, Miss Rosie?
Yeah, I wanted to know if I could make a public comment.
Is it okay? Okay, is that good?
Why don't we set a-
She had makes it.
It's set.
Of course.
So,
That's a CPC.
what is our CC is
The 10th and the 24th.
10. Okay, so we will not have time for 10. So then any of that week, right? 15 through 19.
Yeah.
If you would prefer not to have a week that you don't have meetings, we don't have to meet that week. We can meet after the meeting on the 10th. Let's check does anyone want to propose? We can meet next Thursday, for example. No? Okay. Oh, yes, for our new commissioner, committee member.
I'm
So-
wide open on the 16th,
The 16th.
Tuesday.
That's fine. That's fine
Tuesday,
with
the
me.
16th. Do we have any other conflicts?
What time?
I think that I actually think 5 is a little rush for me, if it's okay for people. 6, is that okay? So.
Was that what we did today? Yeah.
Can we do the 15th? Is that too?
The
I
15th,
can't do the 15th.
What about,
I could do the 18th. Or I
okay,
could
let's,
do-
the people with the schedule and conflicts, please name the preferred day that you want. What preferred day would you like,
I would
Mr.
rather the
Commissioner?
15th or the 17th.
Or the 17th? Do we have any conflicts with, and Ms. Benito has a conflict with the 15th, right?
I have a conflict with both the 15th and 17th, unfortunately.
Okay.
But I could do the 11th. Oh, no, you can't
Which
do
you
Thursday.
can't do the 11th.
I could do the 9th.
Can we do, well, we want to set the meeting. What? So Sharina has a
You may
conflict.
not get 100% on any.
Right, we might not get 100%.
You just need a quorum, so.
If I may, we have, it's the 5 committee members. So is the 9th okay? I'm fine with meeting again. I think everybody's read 2.1 through 4. We can maybe get it for the 10th if we wanted to. But that would be they'll, probably not. Right, that would be hurried.
And we want to send it out to the,
Okay, so then there's no need to meet before the 10th except for scheduling. So please tell me, we are eliminating the 15th, eliminating 16th, eliminating 17th.
I'm good with the 9th.
I would just like to ask that we go back, whatever we end up, that we choose a day, a time or whatever, and make that standard. Because life keeps moving and my schedule fills up all the time. And then when we bounce around, we just, if it's going to be the 3rd Thursday or whatever, let's put it that way. And that gives us the opportunity to do other things. I'm not saying the 3rd Thursday, but Tuesday, the 9th is the police review board meeting. It's almost all day. And I will be attending that every meeting because I think we need to know what's going on in those meetings. So when we do a meeting on the 2nd Tuesday of the month, then that may be, that's all day and into the evening. And I know that other commissioners want to start attending those meetings as well. So
So, we have the 11th, but Commissioner Zayed cannot attend.
Yeah, next week is really bad for me. The trial for my son's murder starts next week and it could be all week. So I don't know if I'm going to be at the
So
meeting,
how about the week after? Thank you. So our next meeting is, the meeting after that is the 24th, right? So we should just aim to have this, and we want to have the rest of the commission read those rules beforehand. So we're 15th, 16th, 17th is out. What about the 18th?
I could possibly. You said what time you said 5 or 6?
I guess we could, I hate to rejigger everything, but we could, if it is easier for you at 5?
It doesn't matter.
Okay, so are we okay with the 18th?
You know what, I might not be able to make it, so just if the 15th or 16th is good, just do it. Either way.
Well, let's make it possible that all committee members can, so let's do the 18th at
I
6.
may not be able to make the 18th, but
Yeah,
go
because
right
I'm
ahead.
saying either way it goes, I have to cancel something, so.
Okay, so what, okay. Dare I say we meet on a Friday? No, we cannot meet on a
No,
Friday.
just do.
All right.
Pick something, Chair, it's in your purview, so just pick one.
All right, it's 19th, I know it's a Friday, is 19th okay? No? Not because it's Friday, because we need to get work done. Is 19th okay? Well, if everyone can meet, then at least we can meet.
I think I always do a doodle.
Well, I would like to set we've gone so far. I think the doodle will confuse things even more. Okay, I'm setting the meeting for the 19th, okay, so everybody can come.
Why are we not doing the 16th, 15th, 17th?
They can't, none of them can
But that's okay, I mean, not everybody can make a meeting.
make, okay? All right, if you want, well, I would like, I think these are foundational rules, so
I think that several of the commissioners here have voiced in the past that Friday's kind of a boundary, and so I don't think, I would rather
It is a
schedule it.
boundary, but this is one sacrifice for rules, and I would prefer inclusion, and I would prefer 5 of us here, so I'm proposing.
I can move my thing on the 15th then, and meet on the 15th.
Okay, we can meet to the 15th then. So 6 to 8 on the 15th. Thank you so much. So just for those listening to this, it will be May 15th from 6 to 8.
And then I think we should schedule the next one just so that we don't end up with such a challenging, because I think part of, if we schedule it more in advance, then we don't, I think in the absence of having like a regular meeting time, I think scheduling in advance is our friend. So maybe let's schedule the next one after this down as well.
And we probably need to schedule a little bit. What is next after the, we have to do evidentiary hearings and evidentiary process?
Yeah.
You're making a big assumption that you're gonna get through all of those first.
Okay, yeah, let's, can we just, I mean, I think this is, I understand, let's just do a doodle for the second one. We promised Rosie some time for a comment. It is nearing 7:54, so we'll send a doodle out for the next meeting after that. Any preferences, just send me the preferences first of the dates, okay? Because I'm not even sure what, Ms. Benito, I don't even know what meeting I have, because I usually meet on the 4th Monday, so I don't know what that means this time. All right,
That was the
Miss
15th, correct?
Miss Rosie, thank you.
Can I get the microphone? You should, please. I'm gonna try to be as gentle as I can. Okay, so I know for a fact everybody is here on the commission for all the right reasons. I know you all think that you're doing the right thing, but this is embarrassing.
Yes.
Okay? It's not any one commissioner. It doesn't matter what meeting I watch or attend, but the public doesn't even understand what you're voting on. It's like something's on the agenda and somebody wants to go ahead and change it. I mean, for us to come all the way down here and think that we're gonna see a 1-hour presentation and then get here and find out it might only be 15 minutes. You know, and then it just, sometimes it seems like you guys are fighting just to fight, and you gotta pick and choose your battles. I don't even understand this controversy. 2 people brought it up. I've watched numerous meetings. People can't follow it. I know the rules are important, but you should have seen the looks on the faces of the 2 union leaders that were at the last meeting. They were grinning and smiling and laughing because you didn't have your act together, okay? So the thing is, you guys can either fight with each other or you can get down to business, okay? And the other thing is, perception is reality. So I'm gonna be honest, I don't know what happened, but it looks like the chairs came in to derail the meeting. I don't really believe you did that, but somebody who hasn't been attending the meetings, if this is the first meeting they watched, I mean, I didn't even know who was in charge today. It's just the whole rules thing is confusing. I can't go online and look at a draft. If section 2 goes up to almost page 50, I mean, how many sections are there? How many pages are there? You know, I mean, you guys have a lot of training to do. You have a lot of work to do, and you just need to get along. And sometimes you got to back down. I don't think some of these discussions are worth it's like we can't even understand motions. Like I said, it's not just this meeting, it's in general. So things being brought up at the last minute, like I thought it was pretty consequential voting on whatever you voted on for the interim executive director. To me, the notion of waiting for a year to do that, I don't know if you guys are planning to do that, but that's ridiculous. I would be out looking for another job. I'll be honest with you. And if I was a staff, same thing. I'd be thinking, if he's not staying, maybe I won't stay. So, I mean, I can't speak for him, but, you know, I'm sure he would definitely be in demand for his skills. And I know a lot of people would like to see him stay, but whatever's going to happen, this should be close to the top of the list, you know? Before you get into trying to discipline people and things like that, you need someone at the helm of the ship. So thank you very much.
Thank you, Rosie. I guess we'll have one last final comment from Mr. Jackson.
All right, thank you. Thank you very much. I appreciate it. Thank you for allowing me to speak, commissioners. Well, the first thing that I'd like to address really is what was talked about with the two attorneys here. The issue of when you're asking for information from the police or the prosecutor's office or what have you. That's why I asked about the paragraph 19, because that was all we had. You guys have 115. So I don't know if you guys are really listening to them, but they really gave you a lot of really good information. I'm not sure which, because things got so muddled up. I didn't understand which thing you were voting on as far as which rule as to whether or not you're going to allow time to get those documents. But if you were really thinking about 1 year, oh my God, that is so bad. Because what you don't know is that when you get to that 1 year, that's when you're going to see the additional time wait. By then, you guys won't even be here. It'll be another commission. I having to start all over again. I prefer 60 days. Gordon is at least being nice saying 90 days. But you need to understand that the minute you do that, that's when you're going to see this. So please don't do that. And one last thing, if you guys are going to try and look at scheduling dates, for the efficiency of your staff, you should have one set date for these hearings or these meetings. Whoever can make it. If they can't, they can't. But that should be one time. Also, co-chair, you don't have to actually go to those meetings. I know that you like to, but you can actually send staff to that if you want, or other commissioners, to increase your own efficiency as to what you can get to so that you can spread yourself around. So anyway, sorry about that. Thank you.
Thank you, Mr. Jackson. Do we have any amount of time? I do want to ask, like, if maybe the bylaws that we've already passed, section 1, can be somehow published so the public can follow on along better. I will discuss this with Mr. Goodrich. Thank you so much. Thank you for hanging in there and with us. We appreciate everybody that's listening. Thank you.
Thank you, Chair Wang.
Okay, gentlemen, I'm gonna do a letter. And I'm gonna